Welcome to Medmarc's webinar series. Today's presentation is titled Nuclear and Thermonuclear Verdicts. What is driving these verdicts and what can we do about it? I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, Sonia Valdes and Andy Hall, thank you for joining us. Sonia Valdes is Vice President for Claims at Medmarc. She is responsible for managing a team of dedicated claims professionals, as well as overseeing technical and administrative issues within Medmarc's claims department. Her responsibilities include directing mass tort litigation, training and developing staff, assisting with policy development, advising underwriters on risk management, and expanding Medmarc's litigation management services. Ms. Valdes has over 30 years of experience in claims. Prior to joining Medmarc in August of 2013, she was Assistant Vice President of Chubb. For 14 years, she had worldwide responsibility for managing Chubb's life sciences claims core. She has extensive experience in evaluating coverage and liability issues in environmental, mass tort, and health science litigation. Ms. Valdes received her undergraduate degree in biochemistry from Rutgers University and law degree from Brooklyn Law School. She's an admitted attorney in the state of New Jersey and a member of the IADC, CLM, and Alpha. Andy Hall is an executive claims specialist joining Medmarc's claims department in 2017. He's responsible for claims investigation, coverage analysis, managing reserves, negotiating settlements, monitoring defense counsel activities, and maintaining good client relations. He came to Medmarc from Wilson Elser, where he was of counsel. Andy is experienced in drafting coverage opinions and interpreting insurance policies, and also works in the product development team, where he assists with drafting language for our new products. Mr. Hall graduated from Wake Forest University with a bachelor's in political science and history and attained his JD from the University of Pittsburgh School of Law. And with that, I am pleased to turn things over to Sonia.
Good afternoon, everyone. Thank you for joining us. I'm going to try and do justice to a topic that has been the subject of week-long seminars. You're always free to follow up with me at the end and ask any questions you have. Nuclear verdicts. Nuclear verdicts you've heard a lot about. A few definitions before I share some of this hair-raising data with you. Nuclear verdicts are defined as verdicts over $10 million. Thermonuclear verdicts are defined as verdicts over $100 million or more. Both of these are driven to some extent by social inflation. And what is social inflation? It refers to all of the ways in which insurance claim costs rise above and beyond general economic inflation, including the shifts in who the society would prefer to be paying these risks. So these aren't just bad verdicts. They are extreme and they really do play an outsized role in our litigation system. The effects of these nuclear verdicts is devastating. Entire businesses can go out and suffer bankruptcy. There'd be a loss of jobs and a loss of communities and communities' loss of services. They drive up the cost of goods and services, and they adversely affect the availability of insurance and undermine, frankly, the confidence and fairness in our legal systems. Next slide. Next slide. Okay, the data. This chart represents the latest study conducted. We do not have the data from 2020 to 2023 and includes a breakdown of nuclear verdict cases. The highest percentage were product liability cases at 23.6%, followed by auto trucking at 22.8% and medical liability. These three types of cases make up 66% of the nuclear verdicts in a 10-year period. Of the products verdicts, most targeted prescription drugs, medical devices, auto, herbicides, mesh, and talcum powder products. Auto were mostly trucking cases. Medical liability focused on nursing home cases and complications during delivery. What's important to remember is the case percentages vary from year to year, but do not change significantly over a 10-year period. The types of cases do vary from state to state. One eye-opening fact is that 90% of these nuclear verdicts were handed down in state court. Next slide. So median nuclear verdicts also increased from 19.3 in 2010 to 24.6 in 2019, or a 27.5% increase. The median is the middle set of values. it is the midpoint. So you have an equal number of data points lower and unequal data points higher. Intentional torts had the highest median. Medical liability came in third at $20 million. Over half of the nuclear verdicts were between 10 and 20 million, and about 33% of these verdicts were between 20 and 50 million. So next slide. Mean is the average, and these figures are really quite stunning. Products liability verdicts were twice as high as intentional torts and 6 times as high as medical liability. While the median is only 20 million, the mean is 76 million, which is 3 times the median. Next slide. Number of reported nuclear verdicts. Here's the breakdown of the values. And looking at the values, there were 9 thermonuclear verdicts exceeding $100 million, which were primarily punitive damages award in 2019. Nowhere near as many nuclear verdicts. There were nowhere near as many thermonuclear verdicts as there are safeguards against excessive punitive damages. There are Supreme Court decisions, notably Campbell versus State Farm, as well as state legislative reforms, which stifle the awards for punitive damages, somewhat anyway. I would be remiss not to say that many of these nuclear verdicts were reduced greatly on appeal, and some of these verdicts were reversed. Another fact is that non-economic, also known as pain and suffering, and punitive damage accounted for roughly equal shares of the total verdicts at 42 versus 44%. Next slide. The top 10 states by cumulative nuclear verdict, not surprising at all. Until recent tort reform passed in Florida, Dade and Broward counties, which are both top 5 judicial hellholes, were where you brought your bad faith claims against insurers. They're terrible venues for insurers in auto cases. Many of the judges there refused to gatekeep, and all issues were considered to be facts to be determined by a juror. The entire state of California is a judicial hellhole, even conservative Southern California. New York falls into a distant third. It is a problem in construction cases, and Texas, surprisingly, is a very conservative red state, has become quite problematic on trucking cases. However, it is very clear in all of these states you're better off in federal court versus state court. Okay, next slide. Up until recently, before Florida passed its wide-ranging tort reform, Florida was particularly difficult for corporate defendants. Nearly 2/3 of Florida's nuclear verdicts were in personal injury and wrongful death cases and involved products liability. That's 38.5% of those cases, and auto trucking, 24.4%. Florida is more prone to punitive damages than any other state. 40% of the nuclear verdicts in Florida had a punitive damages component compared to 25% nationally. It's important to note that 6 U.S. states accounted for 63% of the nuclear verdict, but only had about 41% of the population. So bring it to the present. In 2020, we had the beginning of COVID, year of COVID, nationwide court closures, case filing decreases, increasing case backlogs as a result of the emerging public health measures, which required closing of just about every business, and including the courts. The numbers are really frightening to consider, especially nuclear verdicts relating to Medmarc. Doctors and hospitals reviewed as heroes for their actions during the pandemic. Many of them lost their lives, doctors, but it appears they were only heroes for about 6 months, as the following slides will illustrate. I should state that the data is not available for 2023 yet. So let's look at some of the Medmarc verdicts. After the litigation hiatus caused by COVID, jurors began hitting doctors and hospitals pretty hard. Severity trends for Medmarc have been increasing, and doctors and hospitals have been the victim of nuclear verdicts. Not depicted is 2023, the year 2023, which blew away every record previously set for high medical malpractice awards. In 2023, there were 57 medical malpractice verdicts over $10 million. Among these verdicts was the notorious Take Care of Maya case in conservative Sarasota County, Florida. This case rendered a jury verdict of $261 million, which was reduced to $47.5 million. I'm going to spend a little bit of time. Remember, we're in conservative Sarasota County. Maya was a teenager who kept appearing at Johns Hopkins Children's Hospital, complaining of extreme pain in different joints. The hospital did a number of test studies. Initially, they considered complex regional pain syndrome, but ruled that out in discussions with the mother and the results of the tests. After speaking with the mother a number of times, they began to conclude that perhaps Maya was a victim of Munchausen by proxy syndrome, which is a disease in which the mother seeks attention by inflicting injury on her child. Maya was hospitalized a number of times, and the hospital decided to keep the mother away from Maya during her hospitalization to see if Maya would recover faster. The mother of Maya's mother, who was mentally unbalanced, took her own life, committed suicide. Maya and her brother brought this action against Johns Hopkins Children's Hospital. The jury verdict gave the plaintiff's attorney everything that they asked for. The judge did not set aside the verdict, but reduced to $47.5 million. It is pretty much, it's an outrageous verdict. I encourage all of you to read a summary of it. It's a very long case, but it is really a measure of what's happening out there in the medical malpractice field. I should also take the time here to state that because of the National Practitioner Database, verdicts and settlements against the doctors and hospitals are tracked. That's why we have the information post-COVID for medical malpractice cases, but not for products. Next slide. This is another depiction of how bad the situation has become in the med-mal area. You're starting to see a problematic trend, which is increased frequency of verdicts over 25 million. In 2021, there was one verdict over 50 million. In 2022, there were 8 verdicts in the med-mal over $50 million. I've read a number of articles on what could be contributing to this, and the general consensus is commentators have suggested these verdicts are the result of anger at the U.S. healthcare systems, the cost of medical care, and the cost of prescriptions. Next slide. So this is the last slide, which captures verdicts post-19, the effect of COVID. Severity continues to go up after a dip due to COVID, dramatic increase in the paid severity. And now I'm going to turn this over to Andy, who's going to talk to you about some of the findings.
Thanks, Sonia. Let me plug over here. There we go. So as Sonia suggested, we don't have the full data yet for 2023, but all indications are, quite frankly, nothing good happened in 2023. I found an article from Robert Tyson of Tyson's and Mendes. He's a defense attorney who has his own law firm, and they're kind of big advocates on what defendants can do to combat nuclear verdicts. And the article talked about 2 trends that I think are even more recent than kind of the charts Sonia showed you. One, we're seeing nuclear verdicts in jurisdictions outside of the traditional judicial hellholes, talking Iowa, Montana, places that have been more consistently defense-friendly over the years. And we're seeing them across a much wider variety of case types. So we're seeing them in employment cases and other similar areas. That's all to say, torts, again, as the slide Sonia showed you said, torts are still the main driver of these. You can see there's 2 verdicts I mentioned below, one of which I kind of wanted to illustrate with you quickly, because I think it kind of shows you some of the trends and things we're going to be talking about coming up here. So there was a $745 million verdict coming out of Missouri last year. It's an auto accident case, but it's a little bit interesting. So the driver, who was, I think, in his early 20s, was driving his vehicle. He had a bunch of whippets, which have nitrous oxide in them. He was using them to get high. The stated use for these types of products are for whipped cream, right? You put it in the can and it shoots out. But apparently they're sold in other stores to use for this purpose. So the driver is high on whippets. He passes out, drives off the road. He hits a 25-year-old, I believe she was a radiology tech, and she passes away. So the lawsuit's against obviously the driver, right? But then they sue the smoke shop where he bought these whippets and the manufacturer. The evidence that the plaintiff's attorney put on at trial was, I had two different numbers. One was 40% and one was 75%. But a large percentage of the sales of these whippets are to whipped cream manufacturers, right? So smoke shops, adult stores, other kind of places like that, liquor stores. So the percentage of liability assigned for each of these three defendants was 70% to the manufacturer, 20% to the smoke shop, and 10% to the driver. And I think we can debate the merits of the manufacturer's liability. Obviously, there are warnings on the product that said don't use it in the manner that the driver was using. But what is, I think, most surprising to me is essentially the percentages of responsibility are flipped for what I would have expected, right? The manufacturer ended up with the almost 3/4 of this liability in this large verdict for selling this product. And that's just a good illustration, I think, of the anti-corporate bias we're going to be seeing in some of these upcoming slides. So let me turn it back to Sonia.
Okay, so nuclear verdicts, what's causing them? And there are a myriad of reasons, but I'm going to try and distill them down into a few slides for you. The factors contributing to social inflation is juror perceptions. That is the most significant. Let me share this study with you. A Decision Quest study for 2018 interviewed potential jurors and is profound in its findings on how society views large companies today. 88% of the respondents believe that the company should take any and all precautions, no matter how impractical or costly, to ensure safety of the product. Another 58% of the respondents believe a corporation always has some responsibility/liability for injury, even if a customer suffers injury while misusing the product. That is a hard one to swallow for a company like us that defends corporations. Another reason is the public distrust of corporations. You know, corporate situations like the one in Enron, Philip Morris, the whistleblower, and now you're hearing some of the problems experienced by Boeing. You know, did they put profits over safety? And you're seeing a lot of publications suggesting that Boeing's subsidiary, which is based here in the United States, cut corners. And people hear that and that resonates with them. Another reason is CEO salaries are 10 to 100 times higher than worker pay. And folks have still not forgotten the bailout of banks and mortgage companies. They remember these things. Another reason is millennials. Millennials are the largest generation group in the United States. They are more educated and employed more frequently as white collar workers. They have staggering student loan debt load and some of them are resentful for it. They tend to be more skeptical of the government and its agencies than baby boomers. They tend to be idealists who need to believe that the plaintiff is protected. This is problematic for our clients who manufacture and distribute pharmaceutical, drugs, and medical devices that have been approved by the FDA after rigorous study. Millennials tend to view the FDA's review of these products as a floor and not a ceiling. They tend to distrust the level of review that the FDA has looked at with respect to these products. Other sources, media outlets. It is, to me, stunning that generally younger people in this country get their news from TikTok or Facebook posts. Theirs are generally subjective information, many times by people who have an axe to grind. And then, of course, a very significant one is the perception of the value of money. Athlete salary. Mike Trout makes over $1 billion for playing baseball. The bailout of the banks a few years ago by the federal government, and more recently, the Payback Protection Program during COVID, which cost $800 billion. Folks, jurors are desensitized to large figures. They look at it as monopoly money. So, on the subject of juries, what are the additional factors that are really the cause of social inflation and nuclear verdicts? Three main that most people agree on. And that's the changes in which juries view litigation, including public sentiment about corporations and the appropriate risk-bearing parties. Another one has nothing to do with jurors really, is increased involvement of third-party litigation funding in personal injury and wrongful death cases. And a really significant one is the plaintiff's attorney's use of aggressive psychological tactics such as the reptile theory or anchoring, which appeal to jurors' bias and emotion. And now I'm going to turn it over to Andy for his comments on what jurors are believing nowadays.
All right, everybody, we are going to start with one of two poll questions we'll have here to keep everybody, have you guys have a vote here. So the first question here is, which of these is the best predictor of who will be a plaintiff's juror? And while you all contemplate that and vote, I will tell you that this study comes from IMS, which is a jury consulting company. They surveyed 250 jury eligibles across the United States with a fictional lawsuit where the plaintiff said that her migraine medicine had a carcinogen that caused her cancer. The defendant said, no, that's not true. It doesn't cause cancer. Here are some alternative causes. They presented some essentially outside sources. So they had the FDA who said, we've not been able to demonstrate a human-based link between the cancer and the drug. And then the International Agency for Research on Cancer, which is part of the World Health Organization. I looked this up to see if it was real or not, because I didn't know, who said it could be a potential carcinogen. So Heather, if we can close out the poll results now. Interesting. So you'll see here when I go to the next slide, that figured out. Try it again. There we go. It's actually belief in conspiracy theories. For those of you who 52% of you said demographics and 19% political affiliation, you probably would have been correct 10 years ago, roughly, maybe a little bit more on these. Those two were what I would consider to be more of the typical ways that lawyers and jury consultants and people in our industry are trying to figure out which way you may lean on a case, right? But these are not really accurate anymore based upon this study that we're talking about here. The biggest predictor is the belief in conspiracy theories. And in reading through the article that explains all this, they don't give a good link on what a conspiracy theory is, which I think is interesting because what's conspiracy theory to you may not be to me and vice versa. But that's the number one predictor. And then the number two is extreme sympathy, need to help plaintiff regardless of evidence. That's a theme that Sonia, I think, kind of just touched on with millennial jurors and people of that nature. And then unfortunately for us on the defense side, we have to go down to the third biggest predictor to get anybody who would lean towards the defense. And that's cognitive reflection, which essentially is, I feel bad for the plaintiff perhaps, but the evidence does not show that there's a link. And why this is interesting, I kind of already talked about and alluded to, is it turns some of the ways we think about this on their head, right? I can't look at a bunch of jurors and say, okay, that person said they're a Democrat, so they probably are going to find for the plaintiff. That person is a baby boomer, they're more likely to find for the defendant, things of that nature. And quite frankly, you can take some of those other variables and take two people who may be diametrically opposed, say politically, but if they have a similar belief in conspiracy theories, they both may be finding for the plaintiff. So it's a strange new world that's quite frankly a little more complicated than it used to be in how to look at these things. So then we'll get to our second poll question. And for those of you who paid attention to Sonia's slides, you should probably be able to guess the answer to this question. And that is, do most jurors believe a product should be 100% safe if it's on the market? So Heather, I can't see how many people have voted. So whenever you think we have a good number, you can go ahead and close it. Hey, good news, Sonia. 93% of the people were paying attention. Teasing everybody. But yes, those folks that said yes, that is correct. Right. So per jurors, most are going to tell you that a product can't be safe enough. And so this information that I have here, this came from a really good article in CLM, which is a publication in our industry, and the authors are listed on the slide below. And it talks about this concept called safetyism. And the safetyism jurors essentially say companies need to take every potential measure to make sure their products are 100% safe. You need to warn about every side effect, every risk, regardless of whether it's a big risk, a little risk, a big risk that may only happen once in a million chances. And majority of these folks said that even with what may be more, for lack of a better term, sketchy evidence of a link from a drug or a product or something to cancer, that would cause them to not use it. I would tell you that we've seen this in some of the jury exercises that we've performed. We had one last year where the evidence presented to the jury was that the failure mechanism we were talking about with the product had never occurred before. And one of the mock jurors, when we were listening to the deliberation, said, well, I believe the company is correct that they've never had this failure mechanism with their product before, but now they know about it. So I don't think they should be punished with any sort of damages, but they should have to recall all of this product and fix it. Well, obviously that was a horrendous potential result for us, right? Because the cost of doing a recall would have been well above the cost of the monetary damages this person may or may not have awarded. But again, it's an insight into how these jurors were thinking, that even with knowledge of one potential issue, they thought every product should be fixed. This also tells you, again, I think Sonia alluded to this, the standard is higher than what the FDA said. That used to be the gold standard. It's now the floor. And then the third thing to kind of take away from this is plaintiffs are going to latch on to things that probably honestly shouldn't present it to them. They should not go through the gatekeeping function. So, for example, a study where, rats get cancer from a drug, but a human doesn't. Studies with questionable methodologies, et cetera. Those are going to be important to these safetyism type jurors. Quickly here, again, I kind of talked about the characteristics here, but you're generally looking at these kinds of characteristics for them. They're going to be higher educated, urban, suburban residents, strong Democrats. They believe in science, but they don't believe in science sponsored by a corporation. So that gets to the, I guess, higher educated, but distrustful of companies. Receive their COVID vaccine, which is what I thought was an interesting barometer. It may become less relevant over time. And then that they get their news through electronic means. So those are the two kind of new categories of jurors that we're seeing. And with that, I will turn it back to Sonia. Sorry, Sonia, you're muted again.
Okay, so forgive me. Now we're going to talk a little bit about non-jury kind of reasons what we are dealing, factors contributing to social inflation. And I've got a number of them up there. I'm going to speak briefly to each one. Then I've pulled out a couple because they deserve more attention. The rollback of tort reform. Certain states have had hard or soft caps on economic damages and punitive damages, particularly in the Med-Mal area. Many of these soft and hard caps have been rolled back as unconstitutional. Illinois used to have a hard cap on Med-Mal and doctors liability. So did Florida. So did Texas. California microcap, that is a cap on what can be alleged against doctors and hospitals. It used to be $250,000. It's gone up to 3 times that $250,000, and it'll keep going up every year. Attorney advertising is everywhere. It's on cable, on billboards. The ads are terribly misleading. They mention products and recalls, but don't discuss the regulatory action or the defense verdicts or even the actual amounts of recovery. They'll talk about $1 billion recovered. May that be the sum total of all of the cases, and there are 500,000 plaintiffs. People hear that and they want to run to get into the group that's going to receive this kind of an award. So there are a number of states that are very concerned about attorney advertising and marketing, and have moved forward on trying to limit it to some extent. Third-party litigations funding I thought was so important that I've dedicated a couple of slides coming up after this one. the reptile theory. It has been around for 20 years. It's a plaintiff's tool that is used to trick witnesses into positions where they feel they have to protect the plaintiff and the community at large. They don't make it about the case. They make it about the generalities. And it's been very successful. And as a member of the defense bar, I think we really have to figure out how we're going to deal with the reptile theory. Anchoring is another hot topic. I presented a pull-out slide for you on that. And one of the things that I'm concerned about as well is the exaggerated economic damage claims. These can be as problematic as pain and suffering awards. We have to be able to defend and eviscerate these life care plans and defend these inflated numbers. Next slide. So third-party litigation funding is a term that describes the practice of providing money to a party to pursue a potential filed lawsuit in return for a share of the damages or settlement. It exists all over the world, not just in the United States. Australia's had the longest history, followed by the US, but the US has the largest market share for third-party litigation funding. It had a noble origin, which was to narrow the gap between the plaintiffs and well-resourced defendants. Back in the day, before third-party litigation funding, you had a very wealthy defendant. They could put the plaintiff's small firm lawyer through his paces and cost a lot of money in discovery. These helped bridge the costs and allowed the plaintiffs to respond to well-sourced defendants. It could be used to fund attorney's fees, court fees, and expert fees. And what I've highlighted for you in the second bullet are the types of arrangements, and they have commensurate interest types depending on the type of arrangement you have. Right now, still the most attractive cases for third-party litigation fundings are patent litigation, antitrust, and price fixing. And so, next slide. We need to have disclosure of the exploitative terms in these funding agreements. Let me give you a hint on how some of them are. The funding agreement basically has a very straightforward, we will loan you X number of dollars at a 50% interest rate, and you cannot settle for less than Y. You, as the lawyer who enters into this third-party litigation funding agreement, cannot settle the cases without approval from third-party litigation funders. There are those who suggest this is an impermissible intrusion into the practice of law. Unfortunately, they've gotten the short end of the stick in that argument. It's also problematic in mass torts. You have a group of cases, a lawyer's inventory on talc, for example, and you need to settle the meritorious cases, like mesothelioma cases that are allegedly linked to talc. You have to throw some money in there for the unimpaired asbestos cases, because they won't just settle the meritorious cases unless you throw in some money for these unimpaired cases. Defendants run up outrageous fees having to defend the weak or no liability cases in order to settle the larger cases. To date, only 3 states, Wisconsin, Indiana, and West Virginia, require disclosure, and only 2 federal courts currently require disclosure. That's New Jersey and Delaware. The last bullet point refers to a 2023 litigation finance survey report. It was done by a third-party litigation funder, but it is amazing in the numbers that are revealed and the scope and breadth of litigation funding in the U.S. Okay, the next slide is something that I think many of you have not heard about, anchoring. Anchoring is part of the reptile playbook. It's highly effective and widely used. It's usually used in summation and closing arguments, but it can be used as often as soon as juror selection during the voir dire. Plaintiff will float an outrageous number, usually in the 7 or 8 figures, that is not tied to any damages in the case, and will ask the juror if they have the ability to award such damages. Psychologically, jurors retain that number as a real number, or even as a floor to the damages, because they do not have the experience in evaluating the value of injuries. This number is repeated many times throughout the plaintiff's case. So, as a defendant, how should the defendants respond? Should they provide a number or not? In the past, it was argued that defendants should not respond to this made-up number because it could be interpreted by the jury as an admission of liability or guilt. frankly, I don't think this is the right approach. Most of the time, the jury's not going to award a dollar figure. So perhaps an alternative way to look at it is to respond with a figure that the defense can live with, i.e. something like the amount of plaintiff's medical bills. One of the things we have to do as an industry is to keep pushing legislative to prevent the use of anchoring. About 33% of the states in the United States have measures to limit the use of anchoring. Next slide.
Real quick on that, Sonia, before you go, I was gonna have a quick story. Back in my practice days, I had a case that got tried where we did not really contest liability, but we disagreed on the damages, and we didn't anchor, and the verdict ended up being a lot higher than we anticipated because the jury took the really high number from the plaintiff and essentially our lack of giving a number, and it resulted in a higher number. And I think that case would have been more favorable if we had given a floor that we thought was reasonable. So I just wanted to interject real quick, and I'll move on to your next slide.
Thank you, Andy. So potential responses by the defendant is something I think you want to hear about. And so how do we prevent nuclear verdicts inside the courtroom? How do we attack the myriad of plaintiff practices that are leading to these runaway verdicts? Well, let's attack the reptile theory. As I said, the reptile theory directs the juror's attention from the facts and evidence in the case and needed to evaluate whether a defendant is responsible. It makes it about everything but the case at hand. It's a number of interesting articles on how this works. The reptile theory relies on cognitive bias and fast thinking. If you don't stop to think about what is being said. So I think that the way the defendants ought to think is the mongoose theory, is slow it down and attack the reptile line of questioning with common sense and make it about the case. Attack the extracurriculars, keep it on the focus of the case, make it about the specific acts of the case, not generalities about protecting society. Humanize the corporate defendant. Focus on socially conscious efforts by the company and its individuals. I had a recent trial, one of our clients, AMI, it's Allison Medical. The CEO and founder of AMI founded the company because his daughter died from complications due to diabetes. And this company is dedicated to testing and products related to taking control of diabetes. So this is something that kind of strikes home somebody who's actually experienced a loss and done something about it. Again, I've talked to you about anchoring and aggressively asking for the jury for ever higher awards. The numbers are arbitrary, but they're psychologically powerful. We should counter and make ourselves appear reasonable to jurors. Now, the third one is also from Robert Tyson's book, Accept Responsibility for Something. Now, you need to, honestly, I think you should admit that you admit something, accept responsibility for something. Perhaps admit that you owe a duty to the plaintiff and you could have done it better, but at the same time that it was not the cause of the accident. You need to show sympathy for the plaintiff's condition. Why? Because it diffuses the anger of the jury and again makes you appear more reasonable to the jury. Another aspect that should be considered by the defense is attacking economic damages, life care plans. Attack them viciously. I'll have a slide on this coming up. Attack the doctor's credibility. Did you write the script at the insistence of plaintiff's counsel? And I'm talking about needing 24-hour a day, 7 days a week care for the future for the life of the plaintiff. Argue against the plaintiff's numbers for pain and suffering. Take the time to point out in excruciating detail what the plaintiff's demand is. It would take, for example, plaintiffs 1,000 years to make the money that they are requesting as damages. We at Medmarc use mock trial consultants for the cases that we trial. We think they're very, very valuable. We practice our defense themes and see how the jury responds and the issues in which they consider important. At Medmarc, we also use jury consultants. There's a psychology, and these people really know the kind of jurors that would give you the best response on a given case. Okay, the next slide. So, attacking economic damages. I'm going to pull this out and discuss this extensively. You have to do the work and spend the money. One of the reverberating themes of this presentation is there are defense costs and they're going to go through the roof. If you have one of these cases that have the potential for a nuclear verdict, you're going to have to spend the money. Otherwise, a reasonable settlement is not possible. So the first one is prepare each case as it will be tried. Present new approaches to challenge the collateral source rule. Review the collateral source rule prevents money damages from being reduced by another source such as insurance. You can't discuss who paid for the medical bills incurred by the plaintiff. So plaintiffs can blackboard an enormous number that isn't real and they haven't paid for. But you can't attack the medical specials indirectly if you're barred by the collateral source rule. Attack pricing resources used by life care planners. Life care planning usually involves a case manager whose job it is to identify collateral resources to help the patient recover their costs. Make them discuss their approach and cross-examine their approach. A comprehensive approach to this life care plan is a must. You should also hire an economist to discuss how litigation plans would be invested and challenge the current present value calculation of the plaintiff's life care plan. Many of the plaintiff's life care planners have no background or training in investment. Your investment professional will compute a more realistic return that takes advantage of higher returns in a safer group of investments that leads to lower present values. And as I said before, in many states, you cannot do a direct attack on the collateral source rule, but there's a way around that. Instead, discuss the market value of the goods and services received by the plaintiff. Hire specialized experts in healthcare pricing as opposed to billing experts to support this argument. And now I'm going to turn this over to Andy to talk about corporate responses to these runaway verdicts.
Thanks, Sonia. So we've heard a lot about the data and what's causing this and topics like that, but it occurs to us that perhaps we should give a little advice to our insureds and brokers and people who are on the ground in the industry about these issues. And what can you do to help? So I'll start this by saying you all are in an unenviable position. Really, there's three competing interests that I see. You have your regulatory obligations with the FDA and other regulatory bodies. You want to maintain a successful business. And now we're telling you, you've got this like legal risk management type exposure with these nuclear verdicts. And there's not necessarily one solution that's going to allow you to maximize your return, so to speak, on all three of these interests. But a few thoughts and kind of a little bit of advice. Understand that when you end up in a lawsuit like this, you're starting from a position of anti-corporate bias. So what do I mean by that? What I mean is they're not predisposed to like you. That's what we talked about with humanizing corporations. But in a similar vein, anything that is a hole in your story and a hole in your documentation that's unanswered is probably going to be construed against you unless it can be explained away in a kind of a satisfactory manner. Number two, as we've said before, meeting your FDA, your CPSC, your industry standards, that's not enough. Jurors want more. So how do you work on that? I think this is kind of a holistic approach that you have to think about in kind of all stages of your company. So when you're designing a product, when you're manufacturing it, when you're thinking about warnings, when you're investigating customer complaints, and that is essentially what could go wrong. For example, when you're in the design stage, what are the potential risks here? Where could somebody get hurt? Are we thinking about it? Are we evaluating how to make it safer if possible? If not, are we talking about how we can warn against it? And documenting those. It's not that every decision of that has to be, well, we're going to put an extra widget on the product to make it safer, because there may be other reasons why that doesn't make sense. But if you at least can document that these things are being done thoughtfully, and that that an idea or bent towards customer safety as your number one goal, that's going to go a long way to, I think, getting around that anti-corporate bias. And again, just being able to defend your decisions in that regard. I kind of hinted at this before, adverse events, consumer complaints, take those seriously, investigate them. Do you need to make changes to the product or to the warnings or to the information? Does a customer bulletin need to go out or things like that? Again, not every decision or every instance of that is going to result in the answer of yes. But if these things are being thought of and that they're being documented, that's going to go a long way. And if they're presented at trial with competent company witnesses, this is not an unwinnable case type of situation for us. And I sort of have modified what I would call, like, this is the corporate litigation golden rule, maybe. Would you feel comfortable defending your company's actions on the stand at trial? And if that's kind of something that's in your mind when you're going through these processes, I think that's going to help you prevent these nuclear verdicts as best as you're able. So let me turn it back now to Sonia.
Okay, thank you, Andy. And so what can be done outside the courtroom? Because, you know, you've got some tools on the inside the court. What can be done outside the court? Many of the answers to social inflation crisis, the nuclear verdicts, are legislative responses brought on by the industry and trade groups. If you're a medical device company, work with AdvaMed. If you're prescription drugs or over the counters, work with Bio. It's going to have the Bio, which is a trade organization for that product. It is going to have to be a concerted effort at the state level. I mean, you could say that we are, you know, charge much more money and make it a shortage of a particular product, but I don't think that really works with you. That's what was done by the doctors in the 1990s. OB/GYNs stopped delivering babies. And eventually they got the tort reform that they wanted to, but you're not in that type of position. But working with your industry and trade groups is probably the best way. Addressing attorney advertising, it's a state by state thing. Again, go back to your state legislators and look at the trade groups and bring some of these outrageous attorney advertising that you come across to their attention. Venue and forum reform, again, the same thing. I sound like a broken record, but they've been tested at the U.S. Supreme Court level with some success. General and specific jurisdiction guidance. The Supreme Court brought us Bristol-Myers Squibb, which was excellent. It really took the air out of a lot of cases that we had pending in California. But then they just recently decided the Ford Motor Company case, which kind of allowed the cases to remain in the Philadelphia Court of Common Pleas. So again, appeal these cases as high as you can appeal them, because you need to get these before the Supreme Court for definitive reasons in terms of the venue. The U.S. Supreme Court has been also helpful on punitive damages, and certain states have provided safeguards. That's continued to be helpful. Push for litigation funding disclosure. Yeah, these companies, I read a good article today that said they're on the wane, which is good. That means companies have been making a difference and working with their legislators to get some more disclosure on these hedge funders that are providing the funds to bring these frivolous cases. Whenever possible, you know, bifurcate compensatory and punitive damages. Push to have your judiciary allow this type of bifurcation. It will really help your cases. And then the last slide I have is a positive one, and that is reasons for hope, the silver lining, hopeful sign. A significant factor potentially influencing nuclear verdicts is the judicial failure to serve as gatekeepers for expert testimony. On the whole, we're seeing much improvement here, especially since the amendments to Rule 702 became active on December 1st. The most significant impact of this guidance was the dismissal of most of the cases in the Tylenol MDL before Judge Coate in New York. She carefully reviewed the findings of 3 popular experts from the plaintiff's bar, which kept appearing in multiple different litigations, and found that they did not meet the Bradford-Hill criteria, had to be excluded, effectively eviscerating the plaintiff's theories and allegations in this MDL. Another great case was the Zantac MDL ruling in Florida. Judge Robin Rosenberg dismissed all of the plaintiff's cases, hundreds of them, due to faulty causation experts. What these experts did in their studies was superheat Zantac and suggest and try to create, you heard that right, carcinogenic residue. And they really didn't get a chance to do it. And the superheating really wasn't how people would take it in the normal course of events. There have been this Rule 702 has been helpful in a toxic tort case in New York. It disqualified the plaintiff's experts in the Nemeth versus Brentag. It's a mesothelioma case. So, more to come on 702, but it's been very positive thus far. The second bullet applies to MDL proceedings. Rule 1601, which is likely to pass, addresses case management in MDL proceedings. It's not going to have the impact 703 because Rule 1601 is permissive, not mandatory. What this addresses is the absence of clear rules, which results in a very limited ability in an MDL to weed out the weaker cases at an early stage. This increases the leverage of plaintiffs who can pool resources and divide the caseload. Not terribly helpful to defendants. The MDL has not been terribly helpful to defendants who have to work up these frivolous cases and incur huge expenses. There's really no real benefit to consolidation of the MDL for these defendants. Again, 19 states on attorney advertising have restrictions on advertising by counsel. There have been some improvement in individual states. You'll see them up there, and we will happily take it. And this concludes our presentations. I'm happy to field any questions that you might have if you have a few minutes left.
Thank you both very much. We do have a couple of questions that have come in. First off, what legal and risk management defenses does a medical product manufacturer need to avoid a nuclear product liability award?
I think they really have to know what they're doing on the regulatory side. Be very proactive when you get customer complaints. Document what you've done in response to customer complaints. Document where their product went and to who, and if you have enough complaints, be in a position where you can do a field corrective action. Another way of doing this is looking at it holistically from the outside, is to work with your groups, your trade groups, to try and get legislation run so that you aren't as exposed to these nuclear verdicts as you would be.
Yeah, I think that's right from what Sonia said. And we sometimes see in our claims, because the product side doesn't have the same tort reform that doctors and others have seen, that makes us more of a target even when there's less liability, because we're the only entity that doesn't have those protections.
Oh, is there anything that's being done currently to curtail these nuclear verdicts?
Frankly, the answer is not enough. I mean, they really have the upper hand, the plaintiffs bar here. We keep trying to work with each other. The firms that work in the life sciences keep trying to work with each other to refine arguments, but the plaintiffs bar is absolutely winning. I think it's a pendulum, frankly, and eventually they're going to go too far, and they're going to cause businesses to go bankrupt and a lack of availability of certain products. And that's when you're really going to see, frankly, the reform.
What is one recommendation that you would give to companies who are looking to really prevent this type of claim arising in their business, or if they're in the litigation process already, things that they should be considering?
Andy, I'll let you handle that one.
Yeah, I think it's kind of a combination of some of the things we've talked about, right? Being proactive in documentation of the decisions you're making, and then, quite frankly, make an investment in your company. And some companies, you're not going to be big enough to do this, to have the right people to be your witnesses, to be able to testify at trial, because you'd be amazed at how much of a difference that makes. And testifying is not a skill that everybody comes by naturally, but when someone is confident on the stand and explains what a company is doing and and why they're looking at for patient safety, it can be really compelling. And it's been my experience since I've been in this industry for like 7-8 years now, that life science companies do care, and they do care about patient safety. So I think being able to be good advocates for one another and for your own company can go a long way, at least in your individual case of flipping that bias on its head.
I think that is a perfect note to end on. Sonia and Andy, thank you both very much for your time today. This topic is a major concern for our listeners, and I know that your expertise will be a valuable resource.
Thank you. Thank you all.
Thanks, everybody.
Thank you for joining us. This concludes today's webinar.